they're going to be able to go into the courthouse and they're going to be able to get a copy of the parentage petition, and they will see your agreement.
Super excited to be chatting again with Jennifer Maas about surrogacy. So we did a video on your surrogacy journey and then shared a little bit about the new laws in New York, but somebody requested that we specifically cover the New York laws on surrogacy. So you can introduce yourself again.
Well, thank you so much for having me here. I'm really happy to be able to be here to talk about this. My name is Jennifer Maas, and I am the founder and owner of a solo boutique law firm in New York called the Law Office of Jennifer P. Maas. And I formed this law firm because I went through, as you said, my own surrogacy journey, and my daughter was born via surrogacy, born in New York in 2017 through altruistic surrogacy, because paid gestational surrogacy was not legal at the time. But we have a new law in New York, and now that's an option for folks.
Yeah, it's so crazy that, that New York, which is like such a gay state, you could not do surrogacy. And, clearly gay men need a surrogate. So then they were having to, right. We were missing a part that we needed. And so they were having to go outside the state and go through everything that way. And then that requires like missing a lot of appointments and missing the pregnancy and the journey and, having to travel with a newborn after the baby is born. So now we've got a new law that has opened the avenue to paid surrogacy in New York. So let's kind of talk about it.
Yes. So it's a monstrous law. It's huge. It covers a lot of things, but it really does help a lot of people. And the fact that I went through it myself makes me realize how fortunate I really was, because I had someone that I could go through an unpaid surrogacy with. And not everyone has that. So now the options are open to folks that can find a surrogate through a surrogacy agency that's going to be licensed here in New York and going to be able to do the matching. And like you said, they can be more involved. I was very involved, and going through that, I realized that, how could it be that you would not be involved in all of these things? But in New York before now, you couldn't be involved unless you wanted to get on an airplane every, couple of days to go for a medical appointment or a blood test or an ultrasound. And those are crucial moments for people. So now with the CPSA, it was a bill that was passed after the work of many people for many years, and it finally became law on February 15th of 2021, so just over a month ago. And it's a really great opportunity for people, for gay men, for people with fertility challenges like myself who need to use surrogacy in order to bring their child into the world. With the New York law, it's specifically for gestational surrogacy. So traditional surrogacy is where the gestating surrogate is using her own egg. That's still not allowed in New York. And in most states, it's not allowed. And it's really not a best practice. You get into a lot of weeds with that. But in New York, the gestational surrogacy is where the egg is either procured through an egg donation by the couple, the intended parents, we call them, who are intending to bring a child into the world. And the egg combined with the sperm is then creating an embryo, and that embryo is then transferred to a gestational surrogate, who is essentially the oven and going to gestate your child for the 9 to 10 months generally that it takes for the baby to be born. So the embryo can either be created through the parents themselves, if it's a heterosexual couple and they're each able to give an egg and sperm and create the embryo, or like I said, through donation. And there's actually donation of the embryo itself already created, or with a lot of gay men, there is an egg donation, and then one or both of the men's sperm are used to then create the egg. Obviously, one person's sperm will actually create that embryo, but sometimes both are used to see who's going to be the father as far as biologically.
Right.
So,
all right. Okay. So now we can do this in New York. And okay, so let's talk about kind of preparing. So we know that we want to move forward with surrogacy. let's just focus on gay men. So what do we need to do before we even start this process, legally speaking?
Well, usually the first thing you would do is get involved with a matching agency that would find the appropriate surrogate. And you need to look at the laws that you're going to use. The matching agency would either refer you over to an attorney, or you can find an attorney yourself. Either way, you'll end up with an attorney through the process that will guide you through this. And it's important for the attorney to know where the surrogate lives, where you live, what kind of residency and citizenship you have, and where the child is going to be born. Generally, the child is born in the location where the surrogate lives. So specific to this law, there are residency requirements. So this is really regarding folks that are US citizens. There is an actual requirement in the law that the surrogate and the intended parents all need to be US citizens, or they need to be lawful permanent residents. So that's the first thing. This is not for international surrogacy. For the surrogate needs to be 21 years old. So when you're getting matched, you're going to match with someone that's in that age range, 21 or older. Usually up to about 40 or so. Again, the surrogate's not using her own egg. The intended parents are going to be at least 18 years old. Now, this law is really great because it's gender and marriage neutral. So you could be a single father, a single mother. You could be, a married couple, an unmarried couple, doesn't much matter. This law is applicable to you. So when you go through the process, you're going to talk to your lawyer about where you live, because the law requires that if you live outside of New York, that's going to be a little bit sticky. This law is really mostly going to help people that are New York intended parents working with a New York surrogate. Either all intended parents have to live in New York for at least 6 months, or if one intended parent lives outside of New York, then the surrogate must be a resident of New York for 6 months. So you need to figure out the requirements in terms of which law you're going to use and whether this is going to apply to you. So it's really great if you can meet those requirements, then you can take advantage of the CPSA and this new law.
Okay.
After that, you're going to go through with the matching program. They're generally going to make sure that these requirements are met in terms of having a suitable surrogate. So the suitable surrogate will need to meet certain requirements in terms of a psych evaluation. Then she'll also have to go through a medical evaluation, and that's to make sure that her body is prepared and able to carry a pregnancy. Now, it's not specifically written in the law, but ASRM, which is the American Society for Reproductive Medicine, and the Department of Health here in New York have guidelines that are going to be followed. They're not specifically part of the statute, but they're going to be followed, and that's that the surrogate has already given birth and had at least one healthy, uncomplicated pregnancy. And that's just to make sure that she's sort of a tested uterus.
Oh, wow. I didn't know that.
Yeah, it's generally not going to be a 21-year-old, college student that's trying to make extra money here. It's going to be someone that has been through the process. And that's for a lot of reasons. For the medical aspects, you want to make sure that medically she's more likely to have an uncomplicated pregnancy, and nothing can be guaranteed, but it's more likely, if she's gone through it before, that her body is able to do this. But also psychologically, that's very important that she knows what she's getting into. And if she's already given birth and been through a pregnancy, she knows more what to expect. And every pregnancy is different. And just because you had one uncomplicated pregnancy, everyone needs to understand, doesn't mean you're going to have another uncomplicated pregnancy. But if you're a surrogate, an actual requirement of this law is that you give informed consent. And that's informed consent about the risks that you're taking on, about what the process really entails, and about the parentage, that you're not going to be a parent of the child. And it's important to go through the physical medical examination, to go through the psychological testing, so that in the end, you can give that informed consent. And actually, a requirement of the law is that prior to entering into any surrogacy agreement, that the surrogate actually gives that informed consent. And it specifically says after she's been told about and discussed the risks and the potential complications. And that can include anything from a very uncomplicated, easy pregnancy. That can include nausea throughout the pregnancy. That can include loss of organs. That can include, at the very worst, death during childbirth. And that needs to really be discussed right from the beginning. Mm-hmm. So that's something that all parties need to think about. And specifically, the surrogate has to acknowledge that she understands that and give her informed consent.
Got it. I have a question. With
Mhm.
all of that, so before an agency would even, have a surrogate, I don't know how it works in terms of signing on. That the psych eval and the medical eval, I would assume that takes place first, or at least to
That's
get on their matching directory. I,
that's part of the very beginning. When you're
okay,
working with a matching agency, they get applications for tons of people that want to be surrogates. Believe it or not, there's a lot of people, and we can have a whole nother discussion on who is the surrogate, because I think people's
superheroes.
impression of who a surrogate is very different than who surrogates really are. I think there have been some studies that have come out that a lot of them are married, a lot of them are middle class, a lot of them have jobs, and that's actually a best practice, is to have someone that is not entirely dependent on welfare, social welfare, and that sort of thing, because we want, of course, monetary compensation is going to be one of the motivations, but we don't want that to be the primary motivation,
Right.
because this is a human process, and we really want people to be
Yeah.
involved in that way. It's not a business transaction, even though there are
Right.
business aspects to it. So yes, very early on, the matching agencies, also called surrogacy agencies, they put their ads out and they reach out and they put their feelers out and they get a lot of responses for people who want to be surrogates. Then they have to go through the psych screening, criminal background checks, fingerprint checks, checks on child welfare, prior cases, investigations, things like that. They do the medical, they do the psych. Now they do STD checks, they do a lot of other checks to make sure they're not drug addicts, have mental illness, because a lot of those things will make them ineligible to be surrogates in the first
Mm,
place. And
got
so only a very small percentage of those people that apply to be surrogates will even get on that list at the matching agency.
it. Okay.
Then the intended parent would then reach out to a matching agency, or they will reach out to an attorney who will then help them coordinate and sort of quarterback everything and get them involved with the matching agency. And then there will be checks to make sure that the matching between a specific surrogate and a specific set of intended parents, or an individual intended parent, is a correct match.
Mm,
So at that point, generally, the intended parent and the surrogate will go through some group psychological counseling. It might be a one-time shot where you go in and you all meet together. It might be that the intended parents go in separately and the surrogate goes in separately, because it's not just that the surrogate qualifies to be a surrogate, but you want to make sure that everyone's on the same page, so that that surrogate and those intended parents, or that intended parent, is the right match together. And
oh,
there's a
it's a
lot of
process.
discussion that goes into that.
It's such a process.
It is.
And that's, I think that, I've heard that it can take so long
Mhm.
once you start, it could be like, 1 to 2 years before there's even an attempt at a pregnancy. Sometimes, of course, it might be a lot sooner, but
Right.
it's crazy to think that, because, you know, when you want a baby yesterday. And then to have to go through all of this again, it's like, oh my gosh.
Yeah.
Um,
I
okay.
can
So then,
completely empathize with that, because when I
of
was
course.
going through that, any delay, I was like, oh, are you kidding me? But in
Mhm.
the end, it's very important. I can't stress how important it is, really, to put in the work in the front end. And
Yeah.
all of the professionals have been through this, and all of the professionals know that for the individuals going through this, it's their life, it's their child, it's their family. And they've gone through perhaps years of struggle already
Yeah.
just to get to this point. But this is a journey, and it's called a journey for a reason. And you
Yeah.
really have to put in the time to make sure that you're matching appropriately, because there's so many important things that need to be discussed.
Right. Okay. So now we've got the match. So we've now matched with, our surrogate, and what happens next? What legally things are we going to talk about?
So, to backtrack for a second,
Oh yeah.
before that match actually happens, right in the beginning part of the matching, as part of that match, you need to really be discussing the bad outcomes that could come up, or the touchy subjects. And that's part of the matching. And I just didn't want to skip over that, because that's a really important thing.
Yeah.
Eventually, in New York, the law is that the surrogate is the one that makes the decisions on how many embryos are going to be transferred, on what is going to happen in terms of a selective reduction, if there's some sort of a chromosomal defect or some sort of a problem with the pregnancy itself, or if there's going to be an abortion, if there's, let's say an embryo splits and it turns into multiples, what's going to happen in that situation? So that's all part of the matching process. Also, at the very beginning in New York, there is a surrogates bill of rights. That's part of the law. And that is actually a document. Department of Health has that on their website, and all of the agencies are going to have to give that to a surrogate and really to the intended parents as well, right from the beginning, before they officially decide to match with one another, so that everyone is aware of the rights that the surrogate has in New York. And good practice, best practice, what I do is to give a copy of that surrogate's bill of rights a second time when they come to see me. I want to make sure if I'm representing a surrogate, she's aware of everything she's entitled to. And if it's an intended parent, I want to make sure that they're aware of that. So that's kind of the next step, is to make sure everyone has seen and acknowledges seeing and understanding those surrogates' bill of rights. And that surrogates' bill of rights grants, I sort of put them into 6 buckets of rights that are granted, but of course, each of them are expanded a little bit. One of them is that the surrogate is entitled to psychological counseling from the point in the very beginning all the way through the pregnancy, and that continues for up to 12 months after the end of a pregnancy. And by end of a pregnancy, that could be a termination, a miscarriage, that could be a birth. So she's entitled to that, and that's paid for by the intended parents. She's also entitled to, the second bucket is comprehensive health insurance. And she's entitled to that for that same time period, up to 12 months after the completion of a pregnancy. And that is to cover the behavioral aspects of it. So again, the payment for the counseling and any medical aspects. And that will go for 12 months. And again, that's paid for by the intended parents. The third bucket is life insurance. And the intended parents would have to pay for life insurance for up to for a minimum of $750,000 policy for life insurance for the surrogate. If she doesn't qualify for $750,000, it would be the most that she could qualify for. And she would be able to pick a beneficiary of her own choosing. And again, that would go for 12 months after the end of the pregnancy. So those are those 3 buckets. Then the next bucket is that she would be entitled to independent counsel, legal counsel. So this happens in many states, and ASRM, this is best practices, that both sides are represented. So the intended parents have their own attorney, but the surrogate, and if the surrogate's married, her spouse also has their own attorney. And that's very important so that the surrogate can discuss all of these things in the surrogate's bill of rights, really understand it, and through this whole entire process, understand what's going on and have someone in her corner. Next, the surrogate's bill of rights states that the surrogate is entitled to make all of the health and welfare decisions regarding her pregnancy. So it's important, like, going into this, we're really doing the work on the front end and making sure that people understand what this is all about. It's not, a quick and easy fix to, a problem of not having a uterus. It's really an in-depth process here, and New York law really makes it very clear that it's a very in-depth law. So she gets to make all the decisions about who's she going to use for her doctor, where is she going to deliver, if she's going to have a C-section or if she's not, if she's going to have an epidural or if she's not, what kind of medication she's going to have, what kind of testing she's going to have. Is she going to go through a CVS test? Is she going to have an amniocentesis? Those are her decisions. And there are certain risks to the baby that she's carrying, and the intended parents, that's their baby. That's the goal, is that they will be the parents, and she has no interest in being the parent. She will not be the parent if everything is done correctly, and it really should be. But it's her pregnancy, it's her body, and so she gets to make those decisions. She gets to choose her doctor and that sort of thing. And the last bucket of those 6 that goes into the surrogate's bill of rights is one that's hard to talk about, but needs to be talked about, and that is about selective reduction and termination. And I touched on that a few minutes ago. The surrogate is the one that makes that decision. So it's important in the matching process and upfront when the lawyers are discussing it, if not the agencies discussing it with the folks that are involved, that everyone is on the same page as far as what are we going to do if X, Y, and Z happens? Under what circumstances would there be a termination? Under what circumstances would there be a reduction? And it's important for everyone to understand that in New York, it specifically says that specific performance is not something that's allowed, meaning that if the surrogate says, I will only abort under, X, Y, and Z conditions, but then she has an abortion under A, B, and C condition, well, what happens then? In that situation, it's a very upsetting situation, and it's something that we hope that we can avoid if we do the proper work in the front end, but there's no guarantee. And in that case, the parents are stuck with the decision made by the surrogate. And again, that's because it's the surrogate's body and it's her pregnancy, even though it's the child of the intended parents. So that's something that everyone needs to really think about right from the beginning.
That's crazy.
Yeah, it
That's
is.
so, I mean, I get it's so hard because it's like I am all about a woman's right to choose her body. And also it's like that's not your baby. It's so hard to think about that topic. But
Right,
important, very important to discuss that up front. So
right.
this is why it's so important to, have the right lawyer helping you um, from the very beginning to talk about these hard subjects, and a great thing to talk about with that counselor that
Right.
you're paying for.
And that's the reason why you have that. That's why you have
Right.
the psychological screening, not just to screen a surrogate to make sure she's appropriate to go through any surrogacy, but to make sure she's appropriate to go through this surrogacy with you as the intended parent or parents. And the
Right.
intended parents to make sure that they are matching with the right people. It's the job of all the professionals involved to talk about the hard subjects, because bad things happen, great things happen. Babies are born every day, and parents are made every day, but there are bad things that do happen, and we can't just ignore that.
Right.
That would not be right by the
Whew.
client.
Yeah.
Yeah.
Okay, so we agree on all of this, and we have our surrogacy agreement now between the
Yeah.
intended parents and the surrogate. We
Right.
go in for transfer. Is that kind of the next?
Right. So after the surrogacy agreement, then you can do a transfer. The surrogacy agreement in New York has to be completed before any medication can be taken in furtherance of a transfer. So for anyone who's gone through a transfer or know someone who has, there's a lot of shots that are involved, a lot of medications, a lot of, those sorts of things. Sometimes there's a mock cycle where they, test things out. You can't do any of that until you have your surrogacy agreement. Your surrogacy agreement is usually drafted by the intended parent's attorney, and it's negotiated with the surrogate's attorney. There's some back and forth, make sure that everyone is comfortable in the end. You need to fund the escrow account. So that's how the surrogate gets paid. Remember, this is a compensated surrogacy. And so there are agreements as to what will be compensated. And you put everything in there, nuts to bolts, anything that you can think of, and any seasoned attorney would know that you want to put in things like lost earnings. What happens if she's on bed rest? What happens if the husband is on bed rest? I'm sorry, not on bed rest, taking care of her while she's on bed rest. And he doesn't have income for that time period. What if she can't clean her house, or she can't take care of her other children because she's on bed rest? All of these things need to be discussed. In addition to payments for travel, payment for time missed from work just to go to a doctor's appointment, things like that. So a lot of things are going into this in addition to base compensation. The parties usually agree to base compensation early on when they're working with the agencies or when they're working with an attorney. And that compensation can vary. There is no set amount. I know that we've seen some articles early on talked about there being a minimum or a maximum for New York law. That's not the case. It just needs to be a reasonable amount that is negotiated in good faith. And when that base amount is confirmed, that will be put into the contract in addition to these other expenses and the areas for the expenses. New York law requires that there be an independent escrow agent. So in the past, sometimes the attorneys firms would also have an escrow agency, and they would monitor that and manage that escrow fund. That's not the case anymore. Now it needs to be an independent escrow agent that's licensed to do business in New York as an escrow agency. And that is where the money gets deposited. And the law requires that prior to those medications, prior to any transfer, the base compensation and any reasonably anticipated expenses, like those things I was just talking about, gets deposited by the intended parents into that escrow account. And from there, after all of that is done, I missed one thing, an insurance review. That's another requirement that goes into your, it's pretty complex. Into your surrogacy agreement, you're actually going to state that an insurance review was performed. And that's an insurance review of the surrogate's insurance, if she has any. Generally, like I said, most of our surrogates we find are working women. They, have jobs. They're either covered for some portion of their health insurance through their own employment or through that of a spouse. Sometimes they're not. Either way, there needs to be an insurance review by a competent insurance expert. And most attorneys do not do that themselves. Most attorneys will refer you out to someone that specializes in insurance to make sure that they can see whether there are any exclusions in the surrogate's policy. We want to make sure that the surrogate's pregnancy is going to be covered by her insurance. And sometimes in some policies, there are exclusions for surrogate pregnancies. That shouldn't be the case. Sometimes it is the case. It's important to know that in the very beginning, because the intended parents need to make sure that that pregnancy is going to be paid for. And sometimes there are supplemental riders that the intended parents can get. For instance, if there is there's disability insurance, that's something that she is entitled to, and that would cover lost earnings. That would cover sometimes with certain riders a loss of organs. Those are things that we need to know from the very beginning: what is covered, what is not, what supplemental insurance is out there, and what do the intended parents want to purchase in order to comply with the regulations. The intended parents will also eventually put the newborn on their own insurance. They just want to make sure that that's in place too. So the surrogacy agreement actually needs to outline that an insurance review is performed and that everyone knows where all the insurance is coming from. And if there are any exclusions, it needs to be out there for everyone to be aware of so that we can correct certain problems if we find them.
Got it.
Yes.
It's very thorough.
It's thorough.
Very thorough. I mean, yeah. If you've never been through it, it's not anything that you think about, all the steps that are involved, when you're dealing with multiple people and multiple organs and beings and all of that. Okay. So now that we've got that taken care of, we can move on to transfer.
Transfer, yes. The attorneys will send a letter of legal clearance after all of this is done to the fertility clinic, and you're good to go with the medicals. And then it's sort of in the hands of the fertility specialist that you're working with to do the transfer. Sometimes a copy of that agreement, or at least the pertinent parts of the agreement, will be included as part of that legal clearance letter, or certain paragraphs from the agreement, such as how many embryos people agreed will be transferred, will be in that legal clearance letter. So it's very clear. But again, just a caveat, if a decision is made between the parties in that agreement, it's up to the surrogate ultimately what happens. So she can change her mind that day. We hope that doesn't happen, and that's why we've done the work in the beginning, but you need to be aware that that is a situation that could occur. Then the transfer happens. Hopefully everything goes well, and the fertility clinic will be monitoring the surrogate usually through about the 8th to 10th week, making sure that there is a fetal heartbeat, making sure that the fetus is developing appropriately, or fetuses, and to make sure that the pregnancy is starting off in a really good way. Once that happens, the pregnancy essentially will be transferred over for monitoring to the obstetrician that is going to be delivering the baby and is going to be monitoring the rest of the pregnancy. Again, someone that has been chosen by the surrogate. Usually that'll be talked about beforehand, but again, it's the surrogate's decision ultimately who she chooses to go with and where she chooses to deliver.
Got it. So what's the next step legal wise?
Yes, the next step is generally in the second trimester. Once we know that there is a healthy pregnancy, things are progressing, we've seen on ultrasounds, or parties have seen on ultrasounds with their doctor that the baby is growing in an appropriate way, then we move on to gathering everything that we need for a parentage petition. So in New York, you need to do a parentage petition. In New York, the law changed, so it makes it possible for us to now be a pre-birth order parentage state. Previously, you had to wait until after a child was actually born before you can even file a paper saying that you wanted to get a parentage order. But now one of the beauties of this is that if all of the requirements are followed, the law specifically says that if you follow all of these requirements, the judge shall issue an order of parentage. And that's really why you go through all of this. That's why you jump through all of these hoops and go through all these requirements, because you want to, at the end of the day, you have a child as the intended parent that is yours, and you have your legal parentage established. And for gay men, that's essential. It's very important that you have that parentage order. That parentage order will allow you to both be on the birth certificate, and that will allow you to be able to take that parentage order and move around from state to state, generally with full faith and credit being given to that parentage order, not so much the birth certificate, but the parentage order in hand.
Right.
And that will make it very clear that the surrogate is not the parent, but that the intended parents are. So part of that is that you want to have attorneys that are representing the intended parents. Those are generally the ones that are going to be filing the petition, but really any participant can file that. In there, you want to attach your surrogacy agreement. You're going to need a certification by both attorneys. So the attorney that represented the surrogate and surrogate spouse through this whole process, and the attorney that represents the intended parents. They're each going to have to separately certify that they are familiar with the laws, that they know the requirements that go into a surrogacy agreement, they've read the surrogacy agreement, and that it is substantially complying in all material respects to the law. And with that, the judge should be able to grant a parentage order. Now, it's something important to know that once a parentage order is granted, once this petition has been filed and the proceeding has concluded, everything's going to be sealed. However, it will be accessible upon request by the child and by the parties. So it's really important that people that are going through this, intended parents and anyone really that's a participant in this, understands that in the future, once you have that 18-year-old child, they're going to be able to go into the courthouse and they're going to be able to get a copy of the parentage petition, and they will see your agreement. They will, if it's been attached, which it generally is, they will see the names of the surrogate. They will see the names of the surrogate spouse. They will also see the names of the donor or donors who contributed to the egg, to the forming of the embryo through the egg and the sperm. So I think that it's important that people understand that this is not going to be something that is, put under the covers, something that is shoved in a closet and forgotten about. I think going into this, you need to understand that this is something that is not going to be anonymous. This is something that the child ultimately is going to know about. So you need to kind of think about that from very early on. And it's not the same in every state, but in this state, the child will have access and be able to see all of those things. And in this state, the donor will actually be named in those documents unless there was a sperm bank or an egg bank or an embryo bank where it's truly an unknown individual. But if you know who it is, they're going to appear in there, and they need to know that too.
Oh, wow. I did not know that. I learn something new all the time when I do these videos, which I think is important. We used an anonymous donor, but it was an open. So when our kids are 18, they can contact the bank if they want to find out more. And I hope they do. I want to know him. And be like, thank you so much for your genetic material. Okay, awesome.
Everyone's free to decide what they want, but there's been a lot of studies saying that as these children are growing up and become adults, most of them, I've seen studies that say 80%, 85%, all different amounts, but most of them generally want to know their history. And that's for medical reasons, they want to know their medical history, but also just for emotional reasons. So, I don't think this is a bad aspect of the law, but I think it's something that's very important that people going into this know exactly, what it entails.
Right. So as long as we do everything right, the second that baby is born, those intended parents are the legal parents of that child. Children.
Yes, the order should be gotten in advance through this parentage petition in New York. Everything will hopefully go smoothly with that, and you'll get an order in hand early enough before the baby is born, and that will be handed over to the hospital so they're aware. And when they reach out to the Department of Health to have a birth certificate created, they'll be right on the birth certificate right from the beginning. They'll be regarded as the parents right from the beginning. If there should be any problems, God forbid, a child has to go to the NICU, or there needs to be some sort of a decision about a medical treatment, the people that will be making those decisions clearly and unambiguously will be the intended parents. And the hospital should know that right from the start because of that order.
It's so great. So different than what you went through.
Yes, it is. Yes.
Wow.
I had to wait 9 months after my daughter was born to be her parent. So.
That's insane. And you were the biological.
Yes.
Mom. That's crazy.
It was 100% derived
goodness.
from my egg, my husband's sperm, but my sister was on the birth certificate because, at that time, and that's just in 2017, just a few years ago here in New York, we weren't able to get a pre-birth order, and that was really hard. So, it's really a crucial thing. It's really an amazing thing that people can get that now, and it's going to help a lot of folks.
Yeah, I love it. Well, thank you so much for walking us through all of these steps. And I'm so excited for what this does for New Yorkers, and, opening up these opportunities for, everyone to grow their family, like within the walls of the state specifically.
Me too.
So.
And I wouldn't be a very good attorney if I didn't say that this was for informational purposes and not intended to be legal advice for anyone in particular, but that it is a good idea to reach out to a locally licensed attorney. If you're a New Yorker, you can give me a call and speak about your specific case. Yep. And Thank you so much for having me.
Of course. And we've got lawyers covered, on our directory in all the states. All right. Have a good day.
Bye-bye. Thanks so much.